I'm oftentimes asked, how can you defend drunk drivers? The truth of the matter is, I don't represent drunk drivers necessarily. I've represented a whole lot of people who were accused of being drunk and in most instances actually had consumed some alcohol before they drove. But that doesn't mean that they're not entitled to representation. Every person who's accused by the government of some crime is entitled to effective and zealous representation. And that means that they can challenge the reasons for the stop even if they were drunk. They can challenge probable cause for the arrest even if they were drunk. And they can challenge the chemical test evidence even if they were drunk, because it's the government's responsibility and their duty to prove a person guilty beyond a reasonable doubt. Now, do I condone driving drunk? No, I don't. But the problem is that it's legal to drink and drive, and there's absolutely nothing wrong with drinking and then driving. The law says you're perfectly entitled to do it. And let's face it, every restaurant and every bar out there has a parking lot. Now, it'd be great if we could all afford to have limousines come and pick us up after we've been out on a Friday or Saturday night, but that's just not practical. The problem is that Michigan has set an arbitrary limit out there, that people are somehow expected to know what that level is, and then they have the audacity to charge people on flimsy evidence, flawed field sobriety testing, and outdated breath testing technology that, quite simply, has a margin of error that's unacceptable.